Okay, good afternoon, my fellow emoluments. This is another short presentation on the 10 principles of group decision making presented by loss prevention, in so much as how to proceed once you have been presented with a document or you're going to follow the process, initiate whatever the process is. So, before I begin this presentation, I feel compelled to disclose certain facts about the job you have chosen to undertake. You can expect to see and hear things that will not be easy for you to hear and even make you question your choice of profession. Service is rarely a sunshine and sandy beach kind of job. You can expect to deal with people who do not think or reason as you do. Often they will have a hidden agenda they will not want to reveal to you. No matter what you face, if you choose to proceed, never forget this: the business of another is conducted with scrupulous attention. So, if you don't think you're cut out to do this job, don't sweat it. It's not for everybody. So, also, your success or failures will be measured by how well you balance these three elements as you proceed. The first maxim: there is no closer or firmer link among men than an oath. It's on the cover page of my Judicial Practitioner's Report for a reason. This is the mindset of your constituency. The other mindset is law, being the science of what is good and just. The science is the balance of these three components whose common denominator is established. So now that we can get into what are some of these 10 principles of group decision making, you're going to be getting a lot of remonstrance, parliamentary inquiry, and various other requests for information. So categorization is going to come from Mason's Manual primarily. Now, I know you've inherited certain sets of rules. Do yourselves a favor, take those, throw them in the trash can. So just start with the principles of group decision making. So if that requires just a short up and down vote, motion to suspend the rules, it is what it is. So always start with a book, because number one, you can never go wrong. So if a group, right, the group must have the authority to take the action it purports to take. Okay, so know and understand, if this person or group of people haven't begun this process, probably don't have any authority other than their sovereign authority off the clock. That's articulated in section 73, right? People are vested with a sovereign authority expressed through their legislature. That's you, first pillar. So there must be a meeting of the decision-making group, right? So whatever type of quorum you choose to assemble, whether it's committee, a subcommittee, or the whole body. Proper notice of the meeting must be given to all members of the group. There must be a quorum present. There must be a question before the group upon which it can make a decision. This is key, and it's going to be number 5 is going to be, I'm going to spend some time on that one as we go. There must be there must be an opportunity to debate the question. The question must be decided by taking a vote. There must be a majority vote to take action or decide a question. Must be no fraud, trickery, or deception resulting in injury to another member. That includes the petitioner. And to be valid, any action or decision of a body must not violate any applicable law or constitutional provision. And number 10, I'm going to scrutinize pretty well at the very end, and you're going to see why. So why are you watching this? Excuse me. And where my authority comes from a Texas case where the federal judge said, well, if we're going to enforce basic Magna Carta due process pursuant to the 4th, 5th, and 6th Amendments with these Sharia law issues, right? Let's just, again, I'm going to address the elephant in the room so you guys don't have to. That's the best part about playing bad cop. Sometimes I get to play the heavy. So the court considers jurisdiction pursuant to Title 28 of the United States Code of Section 1443 as far as civil rights removal statute. People that are coming to you, they're going to be claiming a liberty interest or a fundamental right. This is their articulation, their diction. Okay? How do you take that claim and put it into action? Therein lies the question. So my jurisdiction to do this and advise you moving forward comes from right here. Okay? So as long as we're enforcing basic Magna Carta due process, 4th, 5th, and 6th Amendment, you're all good. So here's the judicial mandate that specifically dictates who stands where and why. Okay. In so much as what it is this office does, here's how the court articulates it. Follow Florida law and the rules of the court. So if I ever have to go into the third pillar, that's pretty much the short version. So as we follow due process of law through the legislative remonstrance process in pursuit of emoluments violations, unauthorized practice or enforcement of Sharia law. I'm going to say that one more time. Unauthorized practice or enforcement of Sharia law. Now I'm going to help you differentiate the difference between the Constitution, right, and Sharia law. That's in other videos. Right now we're talking about the 10 principles of group decision making. How I got to those conclusions, we can do other meetings as we move forward. So, in so much as what color of law stems from this word, emoluments, it's in its plural form because it contains more than one component, right? Emolument in and of itself, a singular, is either an advantage, a profit, or a gain, or a benefit if you're talking it's 13th century Latin, right? Hence the difference between the republic and the monarchy, right? In Annals of America, this was recorded as the Republicans and the loyalists to the crown. So now that we can articulate that, we are a republic, whether anybody likes it or not. We go by rules of law. No lawful business can transact without the board of directors. That's you guys. Or Congress, right? So if I'm going to perform some operation from the second pillar, right, we have to closely scrutinize this word. In order to rightly comprehend a thing, it is necessary first to inquire into the names, for a right knowledge of things depends on their names. So these entitlement programs, they're done. It is what I'm going to say that again, they're done. Once we're done with this pandemic and I'm going to just use that word because that just seems to be the buzzword. I think every one of us knows it's garbage. So I'm just going to, again, another elephant in the room, which I don't mind addressing. In so much as who's going to do what to who, right? We can proceed from this principle. No prescription or statutory limit runs against a right by blood, period. Rights by blood are covered under privilege. So if there has been an interference in a right by blood, the question will be put first in the affirmative and then in the negative, not the other way around. And that's the way that the other side is going to do things, because they always start with a dissenting opinion or in the negative. You've heard things like never let a crisis go to waste. There's no news like bad news, right? This is all the negative crap. So if that's what somebody is coming to you with, they can't give you an affirmative. All they want to talk about is the negative. Tell them to give you an affirmative and start with that. So it is proper that every parliamentary assembly should have a certain forms of questions, so adapted as to enable them fitly to dispose of every proposition which can be made to them. Most of what you're going to be doing is going to be repeal and expungement. The expungement is most often the proper remedy. And if you have watched the show cause video on how to handle known theft, I laid that out, 3-step process. It's very easy for you to do. It's how I've done it for pretty much every day of my career. So in the 10 principles of group decision making, right, we've covered the jurisdiction of this office. Jurisdiction must be given. It cannot be assumed. Groups sometimes assume powers they do not have. That's what Islam has done to the Republic. So the predication, the challenge, right, from which these people are going, your constituency are going to come to you, is going to be predicated factually on this Latin principle, specifically definition number 2. The person whose legal position is an issue. You're going to hear a lot about corporations, dog Latin, and all that other good garbage. This is what they're talking about. You're going to hear Article 1, Section 9, Clause 8 being referred to as the anti-bureaucracy clause. You know, again, it is what it is. It's the anti-foreign powers clause. Let's just call that what it is. Foreign powers, foreign pillars of law. So I said, you're going to have bar members jumping up and down, screaming and whining and crying because we're throwing them out on their ear. And so number 2, there must be a meeting of the decision-making group. Okay. When authority is vested in the group collectively and not merely in the individual members of the group, to make a decision, the group must meet and make up its collective mind. Getting 2 people in a room to agree on anything is complicated at best, especially right now. So, why? Because it is unjust for anyone to be judge in his own cause. Know it, accept it, understand that. The people that are going to be coming to you also know, accept, and understand this. That's why they're coming to you. So, what they're asking for is the relief and the remedy. That's what they want. The relief is expungement. The remedy is the return of the property. Any bad actors are going to go where bad actors go. We'll handle them later. The proper notice of the meeting, and you're going to hear a lot about this. I was denied service. I didn't get service of any process. Okay. This is right from the 3rd principle. All members of the group are entitled to such a notice of the time, place, and purpose of the meeting as will enable them to attend and participate. Failure to give such a notice will invalidate actions taken at the meeting. Same applies in all 3 pillars. This includes courts. So if a constituent comes to you and says, hey, I didn't get any notification, or it was conveniently sent to an old address. That's personally happened to me, and I'm not going to lie about it. I found out there was a set of jack wagons in my local area who were sending things to an old address that I'd had in Bradenton more than how many years ago. So I said, talk about fraud, trickery, deception. It's so easy to prove it's stupid. So this is what I mean when I say a concealed intention is an evil one, right? So again, these people are upset, know it, expect it, understand it. Cooler heads are going to prevail, and that cooler head, because of where you're at, is going to have to be you. So there must be a quorum present at the meeting. A quorum is a sufficient number or proportion of the members as will qualify those present to act for the entire membership. A quorum is a majority of the members qualified to act, unless a lesser number is given that authority by proper authority or a higher number is especially required. A member who is not entitled to vote on any particular question cannot be counted to make a quorum for voting on that question. Now, what I'm talking about here is specifically conflicts of interest. And because of the way this Sharia law has infiltrated our system since the early 90s, okay, overcoming questions of conflicts of interest is going to be difficult. My recommendation in some of these cases, don't be afraid to reach out to the third pillar and say, hey, look, we've got some conflicts of interest. Would you be willing to come in and help us get through some of these expungements or some of these repeals, right? Having a judge in the room to bear witness to what's going on will also help eliminate that conflict of interest, right? Because they'll tell you what you can and what you can't do if you're in their court. If that makes sense to you, I hope it does. There must be a question before the group upon which it can which it can make a decision. Well, again, because of this trespass, this stuff that happened while we were at work all day long, this goes right to the repeal. So because these actors assumed powers they didn't have, making decisions that they didn't have the right to make, usurpations of power, right? The question becomes, the motion becomes easy. Motion 39 to expunge, or motion 40 to enter a petition when no other provision is, made by the rules. So either a 39 or a 40, either one is an easy one. So the question may be a motion, resolution, or proper form. It may be oral or in writing, and in most cases should be capable of being answered by an affirmative or a negative vote. A member has the right to know what the question is and what its effect will be before voting on the question. This is where, when I was talking about cooler heads will prevail, reason in law is the perfect equity. So no matter what side of the political spectrum you're on, this is a good legal maxim, one of those fundamental bedrock principles to employ when you're going through step number 5 here. So, number 6, there must be an opportunity to debate the question, right? If it's a simple version of, well, it's easy to vote yes to expunge all of this because it was a usurpation from the beginning. Okay, well, the political debate comes, what are you going to do with the actor who did it? Well, kick that over to the executive branch for an investigation, or that's where you can order the investigation. So, because chances are you probably don't have all of the necessary information. So again, that would require the investigation or an audit, some of the stuff that I do. So I said, don't be afraid to ask. An opportunity to debate is necessary to enable the members of a group to reach a collective judgment. A member has the right to express personal opinions and hear the opinions of the other members. Now, some of the constituency I'm working with, these people are actually pretty decent with a computer. They're going to be putting together short video presentations for you, much like these. So my advice to them is keep it short. I'm doing this as training material just because, again, orders are orders. So as you're going through and you're getting, you can certainly justify cause. For example, an executive agency conducted an investigation, found no wrongdoing. Well, there's cause for expungement. Why? A latent ambiguity in wording is resolved by evidence. See the rules of evidence, right? For whatever ambiguity arises from an extrinsic fact is resolved by extrinsic evidence. That tangible, that thing you've got in your hand, That's just cause for expungement. So, number 7, the question must be decided by taking a vote. You guys know what the rules of voting are. I would certainly hope by now. Okay. The methodology of taking a vote is the thing that's in question, hence what's going on in the news. So when you're looking for people talking about things like sovereign citizens, I would at best call that a dubious expression, because what they're telling you, I'm sure if you may have heard me say this before, what they're actually saying to you is you can be both on and off the clock at the same time. Somebody comes to you with this, hand them a drug test form and tell them to go take a drug test, and after that they're fired. So why? Because a dubious expression is construed against the party using it, right? We don't have time to waste on this irrelevant word salad nonsense. So number 8, there must be a majority vote to take an action or decide a question. Now, this is where we get into one of the fundamental differences between politics and corporations. In corporations, it's one body. We don't mess with political parties in the private sector. Matter of fact, politics and political arguments are pretty much shunned, right? That political correctness, we don't want to hear it. I don't want to hear it. You don't want to hear it. People don't want to hear it. We're over it. They come to you with that politically correct crap, trying to shame you into something. Just dismiss them and get them out of there. So in order to take any action or decide any question, there must be an expression of the will of the majority. Again, I don't care what side of the political spectrum you're on. Use your head. This is usually a majority of the legal votes, but sometimes a majority of the entire membership or 2/3 vote is required. A minority vote or a tie will not take any action. So here's why I say beware of fragments. Okay. You guys, if collectively, if you want a motion to suspend your party affiliation for the purposes of taking a vote, that's within your right. And I highly recommend you do that. There would be nothing that would drive the foreign emoluments crazier than for you in the Senate and the House of Representatives to collectively say, you know what? We're Americans. The hell with this party garbage. It's crap. So this is where we get into there must be no fraud, trickery, or deception resulting in injury to another member. A person, this is your constituent now, mind you, is entitled to protection of the courts from injury through injustice by a body making a group decision as in any other situation involving injury. So what do we know about fraud, deceit, deception, those things? You can proceed from these principles, this principle, or one of these two principles. Deceit and fraud should excuse or benefit no one, and deceit and fraud should always be remedied. Always. This is not a question of if. This is a question of when. So when somebody comes to you and says, hey, I'm not bound to Sharia law, whether they're in a position of emolument or not, that would be an accurate assessment. So in so much as what the executive branch is going to do, we're not going to be enforcing Sharia law. I can promise you right now from the second pillar, I'm not going to enforce it. I'm going to recommend to every agency that they not enforce it. And I have just cause to do that. See Peterson versus Peterson. Congress makes enactments. I've sent policy for you on this. Okay. That's what we make in the private sector with your enactments. The bar, the monarchy, they're the ones who write statutes, which is what's going to lead me into my criticism of number 10. To be valid, any action or decision of a body must not violate any applicable law or constitutional provision, period. The decision-making procedures of any body must comply with the applicable provisions of any local, state, or federal law. The last sentence in red is, as far as I'm concerned, was inserted by the Islamic State. Why? Because the fourth pillar can't make law, In the third pillar can't make law. Even I, as in the second pillar, I can't make law. Why? Because what is law? Land, air, water. I thought God can only make land and air and water. I didn't think man could do that. So, but anyway, it is governed by any statutory or court-made law, including provisions of constitutions and charters. No, that is ass backwards. Constitutions and charters are corporate charters. We're amenable to the people in the private sector no matter what. So charters are, again, that's more Sharia garbage. Get rid of it. Statutory and court-made law. Not in my republic, you're not. Courts don't have the power to make law. They are there to call balls and strikes. Findings of facts, conclusions of law, period. So when they say, can I have precedent on that? Irrelevant. They're talking to themselves. Doesn't mean anything to any of us, because when we come in, when our constituency comes in for the board and we're going to talk about oversight, they're going to say, well, the court does this, court this, or the court that. Well, I can tell you the court's going to say there was no jurisdiction because of X, Y, or Z. Statutes, codes, rules, regulations, and guidance documents, blah, 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 are not law. End of discussion. So, in so much as a judicial, this is where we get into these pillars of law, fourth pillar, fifth pillar. A judicial act before one, not a judge, or without jurisdiction is void. What am I here to do? Explain to you how many different ways you can void and expunge every bit of this crap. So, you want to know why I get away with what I get away with? Because the end result is expungement. There's no trespass with expungement. So, as you go through some of your judicial oversight, okay, here's some principles I want you to keep in the back of your minds or in the front of your minds. You can print this slide and keep it in front of you. A person ought not be judge in his own cause because he cannot act as both judge and party. Most of your constituency actually fundamentally and principally know this. It's the reason they're there to see you. A judge cannot be a witness in his own cause, something I didn't know until I started this project. It is unjust for anyone to be a judge in his own cause. Seems logical. And here's another one. We're going to get into these contempt orders. A judge cannot punish a wrong done to himself. So how are you depriving somebody of a right based on a contempt, right? Being spurned from the throne with contempt, as it was articulated in the Sir Patrick Henry, give me liberty or give me death speech, right? So that was when somebody comes to you and gives you that reference, this is what their perception was. They feel they've been spurned from the throne with contempt, caused to go to war. Look at history. I mean, it is what it is. You know, I don't like it any more than you do. I'd rather be doing the things that I was doing in the private sector, but this is where we are. So when somebody comes to you with an order that says, oh, you're being found in contempt. Contempt of what? Telling the truth? That's cause for expungement, oversight, and potential impeachment of whoever that actor is, whether it's a judge or whether it's an administrator. If it's an administrator, they're fired right now. You can call me and tell me and I'll come and get them. So, in so much as contracts, what I cannot do in my person, I cannot do through the agency, meaning through a contract of another. Fundamentally and principally, I already know this. It was on the test. So now you understand why we can take these contracts, hence the marriage contract. Little hint between us boys here. Don't let your wife find out that somebody engaged her into a domestic violence contract. Yeah, bad plan. My wife was a little more than slightly miffed when she found that one out. So, as in so much as these marriage contracts are concerned, it would behoove you to get rid of that crap. Like, are you done yet? Fast. So, you need help with that, again, call me. This is my corporate charter, right? This is me exercising my right to work. Okay, this is the, pursuant to the letter of the law. You've seen me do that before. There are some errors and mistakes we're going to make on this when we go back for the review, right? It's all right. I'm not worried about it. Judge doesn't seem to be worried about it. So we'll figure it out as we move forward. Reason I created this particular model, okay, these are the ideological, lawful principles employed in day-to-day operations of this company. Stop me if you've heard some of these. Reason in law is a perfect equity. No prescription or statutory limit runs against a right by blood. My intent gives a name to my act, hence loss prevention. A wise man does everything advisedly. Where there is a right, there's a remedy. I mean, I can go use as a fiduciary ownership, hence the fiduciary duty. Rights cannot die. And again, I'm not going to go through the whole things, but there are a couple here. An error of law injures. A concealed intention is an evil one. The crime of plundering or looting is slavish. Innocence alone is free. And of course, one on the bottom left corner, I want you to pay particular attention to. The torture or twisting of laws is the worst kind of torture. If you disbelieve that, listen to the constituent that is reaching out to you. And believe me, they've got stories miles long. So I hope that kind of helps you better understand when you move into the flow chart. Okay, this is kind of a good short version snapshot, right? This one you could pull. This is actually in the open front cover of this book. You could actually have this scanned and laminated and stick it in your front pocket, just kind of right, little flow chart for you to reference as you're participating in a quorum. I actually have made a couple of these and had them laminated, and a couple 2-3 inches long, and it's couple 2-3 inches wide. I mean, it'll fit right in your shirt pocket. So great little thing for you to grab a hold of. Another couple of things I want you guys to remember, and girls, of course, is to these affirmative defenses. The ones that are highlighted: estoppel, fraud, injury by fellow servant, right? And statute of frauds. These are probably some of the key defenses that we could use. Estoppel's a little complicated. I always make reference to fractal calculus if we're going to use estoppel, but if that's required, let me know. So thank you for watching, and I hope this presentation was useful to you, to your group decision-making processes moving into the future of this republic. And yes, it is a republic. Sorry to be the bearer of bad news. It's not a democracy. It's not an aristocracy, et cetera, et cetera. So if you have questions for me, or you have just want somebody call and yell at, hey, happens all the time. I was married twice. Trust me, I'm used to it. You can reach out to me at 16062 Southwest 34 Court Road. That's here in Ocala, Florida, 34473, or by phone 352-470-8460, by email. And this email account does have Dropbox sharing capabilities. So if you have some larger files you wish to send, videos, larger files, either way, you can do it that way. So I hope this, again, I hope you guys found this useful, and I will see you the next time through the next presentation. Have a great day.